Hello and welcome to this session on cookie law compliance. My name is Kuan and I'm a director in Fieldfisher's Privacy, Security and Information Law team in London. Today I'm joined by colleagues from the same team, Senior Associate Natalie Barnfield and Solicitor Hague. This video is part of Fieldfisher's Get Data Protection Fit series. In previous modules, we covered the fundamentals of data protection law, putting data protection into practice, and cross-border issues. If you missed those sessions, they're available on the same YouTube channel. This is the first video of Module 4 of this series. Module 4 is about what else is in the data protection or privacy landscape. And in this session, we will be covering EU cookie law compliance. By the end of this session, you should be better able to understand when cookie compliance laws apply, recognize when you need consent to use cookies, explain the standard of consent required, and give examples of compliant and non-compliant cookie banners. Now, the phrase cookie law is actually a misnomer. The word cookie doesn't in fact appear anywhere in the law. The so-called cookie law also applies in reality to other technologies like mobile apps and Internet of Things devices, not just web cookies or HTTP cookies. But for ease, we're going to call it the cookie law and use the word cookie to mean all relevant data, not just web cookies. So what's a web cookie anyway? It's just a bit of text that's saved to your device and retrieved from your device. Different web cookies have different functions: remembering your preferences, counting the number of people visiting your website, remembering what you've added to your shopping basket to buy from a website, for example.
The law governing the use of cookies actually stems from the European e-Privacy Directive as opposed to the GDPR. Unlike European regulations, which have direct binding effect in all EU member states, directives set out overarching principles and obligations that have to be adhered to, but each EU member state is actually free to decide how to transpose those directive requirements into their local implementing laws. So what that means in practice is that directives like the e-Privacy Directive, they're often implemented slightly differently across different EU member states. In the UK, the e-Privacy Directive is implemented by means of the UK's Privacy and Electronic Communications Regulations, which is often known as PECA. And in this session, we'll be focusing on the laws as they apply in the UK. So while the UK laws do stem from a European directive, it's worthwhile just keeping in mind that there may be variations in the ways in which different EU member states have implemented these rules in their territories. So what are the rules? Well, the rules boil down to two main requirements. First, the requirement to provide clear and comprehensive information. And second, the requirement to obtain consent if you are storing information or if you are collecting information on or from an end user's device, subject to some pretty limited exemptions. So just to break that down in a little bit more detail, you'll be required to provide clear and comprehensive information and obtain consent if you're storing information on a device, say if you are placing a cookie on a device, and if you're collecting information from a device, say if you're reading a cookie from a device or reading or collecting any other information from a device like an IP address, a MAC ID, an advertising identifier, or any other similar sort of information that you can obtain from a device. So in terms of these requirements, they're often referred to as the cookie consent rules or cookie consent requirements. But as you'll see from the bullets on the slide, there's nothing actually in these requirements that make mention specifically of cookies. The rules actually apply to any technology that involves the storage or collection of information from end user devices. So while it will capture the use of cookies, it will also capture the use of other similar sorts of technologies that do involve storage or collection, such as pixels, web beacons, SDKs in mobile apps, and any other sort of similar fingerprinting techniques or tracking devices. So for the purposes of the rest of these slides, when we refer to cookies, we actually mean to refer, or please assume we're referring to, cookies and similar sorts of tracking technologies that I've just referred to. In terms of the requirement to provide clear and comprehensive information, this ultimately boils down to being transparent about your intended use of cookies on the website or app. So that will include describing the purposes for which you intend to use cookies, the third parties that will be operating those cookies, and also information about how users can opt out of them at a later stage. Those are the sort of minimum requirements for information. And in terms of the requirements to obtain consent and how you go about doing that, we're going to cover that in a lot more detail in the upcoming slides. Now, it's fair to say that compliance with the cookie consent rules or cookie consent requirements has historically been pretty poor, pretty patchy. You'll probably see some websites do it a lot better than others, and many sort of that do seek to obtain consent do it very poorly. And the reason for the historic poor compliance is probably because of the historic poor enforcement. However, it's definitely fair to say that we've seen a significant shift in focus of regulatory attention onto this area. A number of regulators, particularly over the last year or so, have issued revised regulatory guidance on the cookie consent rules and have also made very clear that they expect to see the likes of website and app operators pulling up their socks and getting more compliant. So while we haven't yet seen a lot of enforcement in this area to date, it is an area in which we expect to see a lot more. So keep that in mind. Finally, we should mention that the use of cookies may or is likely to trigger GDPR considerations as well. And that's because most of the information that you're likely to be collecting from end user devices using cookies will constitute personal data. So for example, IP addresses, advertising identifiers, and any associated information about a user's interaction with a website or an app will all constitute personal data. And so with that in mind, as well as your e-privacy directive obligations, and obviously the kind of implementing requirements under EU member state laws, website operators and apps will also need to consider GDPR considerations, such as whether or not they've established a lawful basis to collect that information.
As we mentioned on the previous slide, there are two exemptions to the cookie consent rules, and in most cases the most relevant exemption is where the cookies are strictly necessary for the provision of a user-requested service. This exemption is restricted to what is essential to provide the user-requested service, not what might be essential for any other uses you might have in mind for that data. Some examples of strictly necessary cookies include cookies used to remember goods you add to your basket, cookies used for security, and cookies used to actually make the website work. The ICO's website includes a handy table which sets out other examples of which cookies would and would not be deemed strictly necessary. You might find this to be a useful tool if you're looking into making use of this exemption. Although some cookies may be considered important or necessary to improve a site or service, they will not be necessary to provide the site, and they'll therefore require consent. In 2018, the French regulator issued a €25,000 fine to a company that failed to get valid consent to certain cookies. The fact that these cookies were necessary for the economic viability of the service didn't mean that they were strictly necessary for the provision of that service. Another example of a non-necessary cookie is an analytics cookie, which tracks the activity of visitors to the site. For example, the number of visitors and how they've landed there. This information can be used to improve the functionality of the site, but it's not strictly necessary to provide the user-requested service. We'll now look at the difference between first-party cookies and third-party cookies. So first-party cookies are issued by the operator of the website that the user's visiting. Third-party cookies might be set by the website operators, but they've been created by somebody else. An example is Google Analytics cookies, which are used by a lot of different sites. First-party analytics cookies are generally seen to be relatively low risk, although regulators in different EU member states have taken different approaches to this. The Data Protection Authority in France, for instance, has suggested that audience measurement cookies can actually be considered necessary in certain circumstances. Whilst first-party analytics cookies may not be strictly necessary and will therefore technically require user consent, they're not particularly privacy intrusive. In most cases, the information they collect is aggregated and so not attributed to one particular user. Some website operators therefore choose to take a risk-based approach for the use of first-party analytics. However, this view isn't applicable to third-party analytics cookies. These are considered to be higher risk because the third party that operates the cookies may be able to track a particular user across multiple sites that also use their analytics cookies. While they may not know who that person is, there's a risk that they'll have enough data on that user to build up a picture of their activity and their preferences.
So, if you need consent under the cookie law, how do you get it? Before the GDPR, most people relied on implied consent. By visiting this website, closing this pop-up, you are consenting to cookies. However, post-GDPR, consent under the e-privacy directive, specifically the cookie law, has to be to GDPR standard, meaning consent is not valid unless it's freely given, specific, informed, and indicated by some affirmative action. Implied consent is no longer sufficient. You cannot say that the user must change their browser settings in order to accept or reject cookies, for example. And in Spain, an airline was fined €30,000, one reason being that it told users to configure their browsers to accept or reject cookies or decide on a per-cookie basis. The regulator said it doesn't provide a cookie configuration or management system to accept all cookies, reject all cookies, or delete them in a granular way. So basically, you do need to allow consent per cookie or at least type of cookie. For example, agreeing to analytics cookies but rejecting advertising cookies. Also, technically, bear in mind that the timing of storing or accessing the cookie is important. You cannot drop or retrieve cookies until consent has been clearly affirmatively indicated, not just when the person visits the website. So again, in Spain, Twitter was fined €30,000, one reason being that cookies, including advertising cookies, were placed on the end user device the moment that the user visited the website without having done any other type of action. Note that the e-privacy directive is being updated. It will eventually be replaced by the e-privacy regulation. Legislative progress on this new regulation has been slow. It was supposed to come in at the same time as the GDPR in 2018, but so far it still hasn't yet been agreed by EU lawmakers. Once it has been agreed, there should be a period within which to implement it, currently expected to be 2 years. And this means the earliest date when it will be effective is unlikely to be before 2023 or 2024, maybe even later. The current draft of the regulation does include an exemption for first-party analytics cookies, so that first-party analytics cookies used to count visitors to a website and installed by the website itself will no longer require consent. However, this could change, and the position should be kept under review. This proposed regulation is not going to come in during the Brexit transition period, only after the UK has left the EU. So the UK isn't required to implement it, and it could diverge from the EU on this front. We'll have to wait and see exactly what happens here.
So how do you go about obtaining consent and complying with these consent rules in practice? Well, I'm sure you're all really familiar with the really annoying cookie consent banners that are presented to you when you first visit or land on a website, or visit or open an app for the first time. And that's really how cookie consent is obtained. So through the use of what we refer to as a cookie banner, or what's often called a cookie consent mechanism. Now, on this slide, we've included a common example of the type of cookie banner we used to see, certainly pre-GDPR, and it's probably fair to say that we still see a lot of this at the moment. But this cookie banner is not compliant with the current consent rules. So let's just have a look at it in a little bit more detail. So the banner says, we use cookies to improve your experience on this site. And I should say that obviously here we're talking about a website, but this would apply equally on an app. So we use cookies to improve your experience on this site or app, and to show you relevant advertising. By using our site, you agree to our use of cookies, and then the user is invited to read more about it here through a hyperlink. So just considering the GDPR requirements for consent, and in fact the e-privacy directive requirements of consent for cookies. So it needs to be freely given, specific, informed, and indicated by affirmative action. So first off, this banner and the consent that's sort of sought by this banner certainly can't be said to be freely given, because there's no option for the user to sort of refuse it. They can't continue to use the site and refuse cookies. The consent is assumed by their continuing use of the site. So freely given, big red cross. And it's not specific either. So in order to comply with the specific requirement, there'd need to be granular options to consent to the different types of cookies that are being used. So rather than having them bundled into one consent. So it should present a different option for the likes of the cookies that are used to improve the experience, or the analytics cookies, and then separately a consent to show you relevant advertising. So specific, cross. Informed. Arguably the consent isn't informed. We probably can't say just yet without more information as to what's included in the hyperlink, but certainly you would expect, in order for the informed category to be satisfied, that there's a bit more information that a user is directed to within a cookie policy about the first and third parties that are operating cookies, the specific purposes for which the cookies are being used, and how they can opt out of them. So informed ? But we're sort of assuming then it's not satisfied for the purposes of this example. And then finally, the consent is certainly not indicated by affirmative action. So again, this consent, by contrast, the cookie banner that's displayed on this slide is a much better example. So if we just take a look at this in a bit more detail, the banner states, we use necessary cookies to make this site work. We would also like to use analytics cookies to help us improve the site, and advertising cookies to serve you with relevant ads. But we won't use these unless you enable them. There are then 3 checkboxes presented for the different types of cookies that are in use on the site: necessary, analytics, and advertising. And the only box which is pre-ticked is the box for the necessary cookies. And that's because, if you remember from earlier slides, strictly necessary cookies benefit from an exemption to the requirement to obtain consent. And so it's pre-ticked in order to essentially inform the user, I suppose, by transparency, that these cookies are enabled by default. But strictly speaking, there isn't really a requirement to include that checkbox, because obviously there isn't a requirement to obtain consent for these cookies. In this case, one would assume that it's presented there purely for transparency purposes. Again, the analytics and advertising boxes aren't pre-checked. And then at the end of the banner, there's a statement which says, for more information about the cookies we use, see our cookies policy. And one would assume that the cookies policy provides the user with more information about the types of cookies that are being used on the site. So what analytics cookies means, what advertising cookies means, the third parties that are operating those cookies, or whether they're operated on a first party basis, and the means by which the user can opt out of them at a later stage. So as to whether or not this banner meets the requirements of valid consent, thinking again of those GDPR standards that we looked at for the previous banner, consent here can be said to be freely given, and that's because consent isn't implied through use, it's not mandated through use of the site. The user has a genuine choice to check the boxes analytics and advertising cookies. Now, I am making some assumptions about the functionality here of the banner, because obviously if the user is sort of forced to check the boxes before they're able to navigate away from the banner, as I'm sure many of you've seen in operation on some websites with cookie banners, then that wouldn't constitute free consent because the user wouldn't have a genuine choice. But assuming that the user can refuse to check these boxes, click OK and still proceed to use the site, then consent would be deemed freely given. Consent would also be specific in this case because we've got 3 separate checkboxes presented for different specific types of cookies. The consent isn't bundled for all types of cookies. It's very specific, so individuals can choose to select analytics and not advertising if they don't want to. Consent can also be assumed to be informed on the assumption, of course, that the cookies policy provides sufficient information about the types of cookies that are being used, the third parties that are operating them, and the means by which they can opt out. And finally, consent is communicated by affirmative action, because unlike on the previous banner, where consent was sort of implied through use of the site, the user actually has to take a step. They have to sort of take an action to check the box in order to communicate their consent. It's not sort of simply implied through use. So all in all, a much better banner and a much better cookie banner example here. But of course, there are huge variations and a lot of varieties of cookie banners and compliant approaches that you'll see across the internet.
Thanks very much, Natalie and Ali. That brings us to the end of the first session of Module 4 of Fieldfisher's Get Data Protection Fit program. What else is in the data protection landscape? You should now be able to better understand when cookie compliance laws apply, recognize when you need consent to use cookies, explain the standard of consent required, and give examples of compliant and non-compliant cookie banners. The next session of Module 4 will cover the EU rules on direct marketing, including e-marketing. And here are our contact details should you wish to get in touch for advice on this area. Thank you very much for watching this video on EU cookie law compliance.